Okay, let's get on the record and call cause number 4673 in the matter of the marriage of Tiffany McClarty and James Bloucher. We have several motions set today, a motion to modify temporary orders, a motion to compel discovery, and a 215 motion is what I have on my docket. All right, I'd like for you both to summarize, what brought us here today and your positions on both. Let's start with the petitioner. You're muted, sir. There you go.
That happened. There we go. Super. Richard Naylor, attorney for petitioner. We initiated the initial pleading. We filed initial pleading seeking to have a discovery dispute resolved by basically saying we're not getting the discovery, and now we need the other side to have their ability to move forward at trial sanctioned. That's what the rules provide for in appropriate circumstances. This was the case, and I'm going to try to summarize a lot of stuff that we may want to go into in more detail later, Your Honor. We'll kind of leave that up to you some, but you asked for a summary. This divorce petition was filed back in June. Mr. Blucher initially represented himself. He came to my office. We explored the possibility of trying to get this resolved by agreement, then moved on into me issuing discovery. He provided some discovery. I advised him it wasn't full and sufficient. We wasn't giving us all the cards we needed to see to be able to say what we wanted to do in a final way. Asked him to get some more. He brought in some more. It still wasn't complete. We basically advised him of the same thing. We need to have all the cards on the table so we make an adequate response. Then he elected to bring in a counsel to represent him, Mr. Abbott, in his office. That was back in, my recollection is, in August, whenever Mr. Abbott and I first visited before another hearing, another unrelated case. He said he's going to be brought in. I advised him then we had some discovery outstanding, and that's what we needed to get done, taken care of at that point, so we could move forward with move the case forward. 7/10/2025, I filed official discovery. 7/14, we had those discussions with Donnie. And then, Your Honor, to cut to the chase, I know you and I haven't had an opportunity to practice together, so we don't really know each other very well, but I try to be very straightforward with a judge when they ask questions like, what's the deal? My client found out on August 18, 2025 that she's a horsewoman, Your Honor. And she found out that she was going to be able to compete in a national, maybe even international competition called Road to Horse. And it's a horse training competition. And the key to that is that she may be able to earn a top prize of $95,000. This is a marital estate that certainly isn't large, as many aren't, but that would certainly change the situation quite a bit for this case. So in August, we certainly started pressing to get this matter. By the way, I left out some key information there. It's going to be held and concluded March 22, 2026. Possible earnings of $95,000. Obviously, the divorce pending for months at that time. We wanted to get the discovery in and get this thing before you, if it wasn't going to be resolved by some type of agreement, and not have that issue to be resolved by the court and judicial discretion, those kind of things. So we started pressing very firmly for moving forward with the discovery. As you can see from the fairly detailed Rule 15.2b and Rule 215.13 motion, we gave them all of our
Mr. Nadler, I'm sorry.
Yes.
When you turn your head and move away from the microphone, it's really hard to hear you. I didn't hear that last sentence.
Okay, well, my apologies, Your Honor. I'll try to keep that in mind. I seldom get told that I need to talk louder, but I'll do that. Uh, Rule 215, we filed the Rule 215 2B and Rule 215 3 motion, Your Honor. I believe it sets out very clearly uh, how many times we simply said, give us full and complete discovery so we can move on to step B. We didn't get it. We didn't get it. Fine. We gave them everything. I've got an email here where I sent all of our documents over to them in early September. To my knowledge, they've got everything that we have document wise. We were trying to move this thing forward, been trying to move this thing forward, and basically couldn't get it. Filed a motion, called your court, Gloria up, said, hey, we need a hearing date. We're going to be filing a motion for discovery, impetus, and sanctions. When can we get some dates? That was on October 14th. Got some for in November. Then we filed the thing on October 30th, started trying to get it set, ran into some conflicts with the other side's schedules, and continued to have communication after communication trying to get this seminal issue resolved. And of course, in 215B says, hey, if you haven't given full and complete discovery, you can't go to trial and put on evidence. Our position has been, Your Honor, by the time we go through, then, pardon me, let me back up a little bit. Then after we had to file a formal motion and seek that type of full and complete sanction, the other side started saying, well, now we're noticing you for depositions and we're issuing discovery. Well, with a motion pending saying we hope to not to have to have any discovery because you've already put it to a point where nobody can really complete discovery in the amount of time left. They started pursuing those things. We filed a motion to quash. We filed objections. The rules very clearly say the result for that is anybody wants a hearing on those things can then request a hearing and have it determined. They didn't. They filed a motion to compel, seeking sanctions. I think that's totally inappropriate, totally outside of what the rules clearly call for. As we go through it in a trial, I cite you chapter and verse of the rules on that. And so here we are, months of scheduling and new motions and new arguments. And all we've been saying since basically back in July is, here's the discovery, give it to us. We don't have it yet. Now it's too late to get it. In time for us to engage in the type of standard discovery that we normally would if they gave it to us, depositions and filling out what the documents don't show and getting more documents in and maybe bringing in other witnesses like accountants and people who have bought horses. All those things could have happened if we'd gotten the information in so we could move forward with discovery in a timely fashion. We didn't. After, in good faith, repeatedly saying, please give us all this information so we move forward, we had to file a motion. And that's the motion that I think controls what the court determines is right and appropriate today. And our problem is it's a very unusual case. I've been practicing law since 1983, and I've never had one that I thought would properly result in saying, hey, other side, you can't put on your evidence because you didn't give up discovery in a timely fashion, but we asked for it in a timely fashion. We re-asked for it in a timely fashion. We re-asked for it in a timely fashion. And now, since we filed this motion, it's too late to get it in and get this thing determined with full and complete discovery before this $95,000 question may come in that the court, matter of law, comes in during the marriage before the divorce hearing. It's presumed community property. So they backed everybody into a corner by simply not getting their discovery done within 30 days as required by law, despite the fact I told him personally 2 or 3 times. In fact, that's the first thing I mentioned to opposing counsel in August, mentioned it again several times before filing the motion, as the motion notes, didn't get it done. And so that's where we claim we're coming from, Your Honor.
Okay, response?
Okay, Judge, I'm going to give you a summary. First of all, these two have been married for 3 years. They've been separated for a year and a half. We're set for a final hearing in February, and we think a motion for continuance is probably going to come next, and we're definitely opposed to a continuance. This case needs to be resolved. Mr. Naylor's 215 motion is asinine. We have responded to him. We've given him 775 pages of documents. We've given him 775 pages of documents. I've got a summary of things we've given him. I have been asking him for a list of what he thinks he is missing since day one. Since we stood in the courthouse, I asked him for a list. And the response I got was, we want everything. I don't know what that means. I sent him a letter back in November, and I said, give me a list. No response. I followed up on that 2 weeks later with a letter. Give me a list. No response. I finally started sending him letters asking for these things and putting them in the court file so that you could see that we were asking him, tell us what you want. In his motion to compel, he still doesn't say what he's missing, and today he doesn't say what he's missing. I can't read minds. I'm really good at my job, but I cannot read minds. If they won't tell us what they think they're missing, we can't tell them if we have it. We can't provide it to them if we don't have a specific list. I have given him everything I have. Everything I have given him because I don't want to get to trial, have a document, and you say, understandably, you didn't give it to him. Everything I have for trial, I have given him. And yet to this day, he will not tell us what he wants. We have discovery to do. I sent him written discovery. He flat out ignored it. He didn't object to it. He didn't respond to it. He didn't do anything with it. That's where the sanctions ought to be. I asked him for deposition dates. I've asked him repeatedly for deposition dates, and I either get no response or I get, well, I've got a 215 motion on the table, and that ought to be heard before we do depositions. Why? Why can't I ask her what her claims of fraud are in this petition? I just get crickets from the other side. And we're a little annoyed at that at this point. So here's what I'm asking you to do. If you want to give them anything, give them an order to give me a list of what they think they're missing. And we will give them those documents if we have them. I doubt we do because we've given them everything we have. And then make them let me take her deposition. I don't care if it's on a Saturday. I don't care if it's on a Sunday. I don't care if it's 7 o'clock on a Friday night. I don't care when it is. I will work with Mr. Naylor's schedule. I will take it anytime by Zoom. I'm asking you to award $800 in attorney's fees for me having to deal with this nonsense. And I'm asking you to keep this trial set. I'm asking for 2 more things. She has 3 separate property horses that are at Mr. Blucher's place. He wants her to come get them. We're going to be at trial in a month. I don't know if she's planning on leaving them there for infinity, but she needs to come get her horses, preferably this weekend. She has things at Mr. Blucher's place. He wants her to have her things. She needs to come get them this weekend. We don't think that's too much to ask. So we're asking you to deny their motions. And at this point, you may say, look, you've had plenty of opportunity to give them a list, so I'll leave it to you what to do there. But we're asking you to order us to allow her deposition. And quite frankly, they're past the discovery deadline. They could have taken his. Now, if you want to order both of them, we're fine with that. But we think we ought to be allowed to take her deposition. And we want to try this case in February. We don't want to put this off anymore.
What date do we have this case set for trial?
It's either 18th or 19th of February.
February 18th, Your Honor.
Thank you.
And we're going to ask you not to grant a continuance because I think that's the next thing that's going to come your way. But it's not on the table today.
Well, Mr. Naylor, your client's concerned about this income that might come to her in March. So wouldn't it be in her interest to go ahead and keep the trial setting in February?
with them not being able to bring in discovery they haven't given us, Your Honor. Yes, that's exactly what my motion since October 30th has said. Please, and just so you know, and please, Your Honor, I'm very sensitive to the fact that you have many cases, and your court clerk does an admirable job of juggling all those and getting them set up. But the first thing we basically said to your clerk was, we called her up and said, when can we get a trial setting and a hearing on a motion to basically a motion to compel, motion for sanctions? That was in mid-September. When we filed the motion that day, October 30, we sent a request to your clerk saying, and this is, please read the motion, after we've been saying to them for months, give us full disclosure, and they didn't. Because my client, one of the key issues here, Your Honor, and I'm sorry for being long-winded, but I am trying to focus on the arguments before we maybe call my witness to go through the things that haven't been produced and have never been produced. But basically, we went through all of that for months trying to get in full disclosure, which what we're going to show was very clear and didn't get until almost 2 months after we filed the October 30 motion for sanctions. Then we start getting in some more documents that go to this issue. That there's an LLC involved here. Now that was started during the time of the marriage. She was listed on the original documents. She put cash money investment into that LLC, and we weren't getting. And then when the divorce comes along, Mr. Blucher and his partner, other members in this LLC, all of a sudden remove her from any access to the business, cut her off the bank accounts, cut her off the credit cards, and have given us no indication of how they did that, what procedures they followed, how much money they're earning, interest, equity. None of those kind of things were coming in. My client knew that there were documents. I asked him for 2 months. Give us the documents that show about this LLC. I asked him. He says, I'll get them together. He didn't 2 times. He then says, my partner members and his wife have those documents. Okay, I call them. They don't give them to us. Then attorney gets involved. I'd say we need the documents we requested formally. You have your client had 30 days. By the way, by the time they can't complain about any of the they can't object to the discovery because they didn't make objections within 30 days because they didn't even hire a lawyer within the first 30 days after discovery was issued. Didn't get the discovery, still don't have the discovery. All of those issues, which we can go through in just a moment, item by item on what we don't have extensive. Now then they're saying, oh yeah, let's go to trial, but you don't have all that discovery, but we can put on any discovery we want. That's not the way the rules are set up to work. We don't have to tell them, hey, we're going to acknowledge what we know you don't have, what we don't know you don't have, so you can continue to hide what you don't have, what you haven't produced. The rules say you, as a party, have a duty to read very straightforward, very standard discovery requests and disclose fully. And with the court's agreement, I will call my witness and we'll run through those things that we've asked for, that this 720-page document dump. Still, first of all, we got some documents. November 20th, almost 2 months after we filed a motion to compel and for sanctions of the fundamental limited liability company information that was very instrumental. My client knew that she'd seen those records, knew she was on them, didn't get those until November 20th, and still they're just partial responses. So that's why from the get-go, ever since this potential $95,000 earnings has come up, all we've had from the other side is delay, lack of complete disclosure as mandated by the Texas Rules of Civil Procedure. We repeatedly asked for it, filing a motion to get it. We get a partial disclosure and we still don't have it all. And yet then whenever we finally is kind of, might not be quite the word, but after we do get a final hearing that we've been asking for a couple of months from this court to be set in February, that's whenever they got very busy about now they want their discovery, even though they have not fully complied with our discovery to such an extent we've had to file a motion for sanctions seeking to exclude their right to introduce any discovery. And so, yes, it would be ludicrous for somebody to say, we're going to give you discovery with a motion pending that suggests the judge may not allow you to have it at this point because of your prior transgressions in the discovery arena. Now then, with all of that said, I would request an opportunity to call my client as a witness regarding the documents after reviewing the 720 pages that were finally delivered some 4 months after they were due, 3.5 months after they were due in November 20, still are woefully insufficient and should be considered in determining whether or not this party is engaged in either intentional hiding of the discovery ball or gross neglect in simply getting their act together in a timely fashion as mandated by law. So this case could be moved forward. We wouldn't have a problem with $95,000 of potential income caught up in a delayed trial without full disclosure.
May I respond?
Yes.
I'm not sure why you need testimony. What I'm hearing is they have a list. They have a list that I've been asking for. Just give me the list. If I have them, if I can get them, I'll give them to you. If I don't have them, I'll tell you I don't have them. I can't give them to you.
Okay. Mr. Naylor, you want your client to go ahead and identify which documents she believes have not been produced?
Yes, Your Honor, if I might.
Okay, go ahead and let's call
Your
her.
Honor, basically, we're going to be working off of the very standard customary request for information that was submitted to the other side. Number one, Tiffany.
Let me go ahead and swear her in.
Yes.
Raise your right hand. Do you swear or affirm the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, before your attorney starts asking you questions, please go ahead and spell your first and last name for our court reporter.
It's TIFFANYMCLAURY.
Okay, you may proceed.
Very good. The first item that we asked for were all documents, including invoices and billing statements, evidencing the contractual relationship. Strike that, Your Honor. Let me give a little predicate for the court's benefit. Have you reviewed all of the documents produced by the respondent as they have come in? Have I gotten them to you and had you review them?
Yes.
And have you reviewed the information we requested from the other side at your direction?
Yes.
Okay. Now then, subject to that information, you asked for all documents, including invoices and billing statements, evidencing the contractual relationship with attorneys, experts, and/or investigators in connection with the case.
Judge, I'm going to object to leading.
I'm
If
just
we
reading.
ask what documents she's missing. Can we just get to that?
No, you're asking what documents are missing. We're going to go down the list that we gave your client 2 months before you appeared in your office, counsel, and say, did you ever get these and when? And so that's what we're trying to do.
Okay. Mr. Naylor, I do want you to cut to the chase. We're taking up a lot of time here, and if you know what's missing, I want you to go ahead and ask that question to your client and have her identify what's missing.
There are about 20 things that are missing, Your Honor.
Okay, well, she can list 20 things then.
Very
Let's
good.
get on with it.
All right.
Sure.
Number one, were those there?
There were no invoices or
Number three, all letters and correspondence, including electronic writing that constitute or contain matters relevant to subject matter of this lawsuit. Were there any emails?
Judge, I'm going to object to leading. Again, if he's got a list, tell us what the list is.
It's the list that was served on you, counsel. I'm just reading off of the request for documents that was served on your client.
Judge, we're
Mr.
going to be all
Naylor.
day at this rate.
Okay. Asking,
Yes,
we
ma'am.
need to know what specifically she knows exists that was not produced.
About 20 things, Your Honor.
Okay. Let's go through them. And if she knows there's an invoice, I need her to give me her personal knowledge of why she thinks that document exists, whether she's seen it or how she knows about it, and why we know for a fact that it is in existence and is in fact missing.
Okay, let's go to item number 5 on the request for production. We ask for all federal, state, and income reporting documents, including tax returns, etc. What is your answer to what they actually gave us?
The 2024 personal tax return for Mr. Blucker was not included, and he did receive a refund on 10/15 of 25.
Okay, moving on to request number 10. Respect to all accounting reflecting funds and mutual funds. What did your review of that request indicate had not been provided?
All of the statements from the savings account,
A and B.
A and B savings account were not provided. There was no documentation regarding his daughter Carly's account, which he opened for her and had access to. And there's no documentation of payments from Chuck and Elaine, who are boarders at his house.
How much was that in college?
They are on full board for their horse, which is $750 a month. He usually cashes these checks.
Okay. Moving on, item number 14.
I didn't, Judge, I didn't understand what that last item was. What's the
Okay.
item they're asking for?
Okay.
I've got 2024 tax return,
Mhm.
personal return. I've
Mhm.
got the A and B savings account.
There was no information regarding the horse boarding income my client's aware he was earning during the marriage from Chuck and Elaine in the amount of $750 a month.
Chuck and Lane. All right.
Chuck and Elaine.
What was the last name of those folks?
I do not know their last name, Your Honor.
Okay.
All right. Moving on to item 18. All
Wait
records
just a
relating-
second. Wait just a
Yes,
second.
Your Honor.
Ma'am, I believe you testified something about his daughter's account.
Yes, ma'am. She has an account with Emerald National Bank, which Donnie opened for her and had access to. And there was no documentation for that account.
What is her name?
Carly
What is her last name?
Blucker.
Thank you. Okay, go on to your next question.
Very good. Thank you, Your Honor. Let's see, 18. We requested all records relating to safe deposit boxes maintained by you or on your behalf, including records of entry. What is your knowledge of what might not have been provided in discoveries in regard to that request?
I'm not aware of any safe deposit boxes, but there is a safe on the property. I've never seen the contents of it, and he has claimed to he's forgotten how to enter the safe. But I know he has things in there. Whether they're relevant or not, I'm not sure.
Do you know if there's any documents in there?
It's a possibility. I know there's the registration papers for a horse that we have come up missing, and they have not been where he has said that they were. So that's a possibility that they are there.
Okay, this registration for this horse, is it something that you've asked for in discovery?
She is involved in she's community property.
Can we have the name of the horse? I'm sure my client
her registered name is Third Time's a Charm.
Okay.
And Your Honor, of course, in responding to discovery, it's incumbent upon the party responding to say, here's the documents we're giving in response to these specific questions, so that it's not just a big morass of 722 documents. Say, number 18, here's what's in the safe deposit box or not in the safe deposit box. They can answer that, but we don't have anything that denominates what this 722 pages of stuff is and isn't. Therefore, it's of no value in fully preparing for trial. Now that we would like to move on to paragraph 20. You asked for all certificates of title and current licenses. What do you understand from reviewing the documents wasn't produced there?
Title or registration receipts for the truck that he owns.
Okay. 21. All policies of it, you asked for all policies of insurance, whether life, health, automobile, disability, etc. What did you find in response to that? Inquiry number 21.
There were no insurance policies of any type included.
Okay, number 22. You asked for copies
Wait a
of
second,
all
wait a
original-
second. Let's back up.
Yes. Yes.
You said no insurance policies were included. I need you to identify what you expected to be there.
His auto policies, health insurance policies, life insurance policies, homeowners policy. Those are the ones that I would be aware of.
Do you have any idea about what companies were used for those? Can you identify them any further than that?
I know the auto policy is through Nikki Dole. She's a State Farm here in Amarillo. I believe she handles the homeowners as well. The health insurance is through the Veterans Program. I'm not sure the exact name of it. And I'm not sure what any life insurance policies would be under.
All right, go ahead.
Thank you, Your Honor. Item number 22 you asked for copies of originals of all credit files, loan applications, credit applications, promissory notes, guarantee agreements, etc., to which the respondent was a signatory since June 10, 2023, the date of marriage. What did you see in the records produced in response to that request for documents?
There were 2 loan advances through the A and B checking account. One was on June 10th of 2024 for $4,000. I'm not aware of what that was for. And there was another loan on September 16th of 2025 for $2,000. I'm not aware of what that was for. I just saw that on the bank statements themselves. There was not actual documentation of the loans.
What was the date of the 4,000 advance?
June 10th, 2024.
Okay.
Moving on, Your Honor. Item 25, see if there's any any credit card debt floating around out there that you might need to be aware of in resolving the divorce action. You requested all credit card statements, annual summaries, and receipts for expenditures made and indebtedness incurred by respondents since June 10, 2023. What did you see there that you believe was not full and complete?
No, there is a discount tire card and a Best Buy card. There were no statements of any sort relating to either one of those accounts.
Okay. Item number 32. For the period from June 10, 2023, please produce all your electronic data, including but not limited to any messages sent and or received through the application known as WhatsApp, and authorization for Katie Lynn McCat, pardon me, that's a misprint, Your Honor, digital artifact from another case, to access such records and devices to attempt to obtain and recover information. And let's combine that with 33, all your data not limited to messages sent or received through any social media accounts, text messages, entire contents, and authorization for Tiffany McClory to access such records. Now, I'm going to amplify a little bit on that, Your Honor. The LLC, somehow or another, these guys were running it after they basically kicked her out without any notice, or we don't believe authority, cut her off from the LLC that she invested in, that they continue to operate. And we want to know if there were communications back and forth between them. What did you find in regard to the response to that type of information we requested?
Information or access was.
I can't hear her. Neither can the court reporter.
I'm sorry. No information or access was provided for either one of those items.
So I don't understand what they're asking for. Are they wanting to dig through his phone? Are they wanting
Text
they
messages,
want to make
counsel.
his-
Text messages for one, counsel.
You want every
Emails, text
text
messages,
message he's ever
electronics.
Okay.
Yes.
Gentlemen,
since
don't
the
speak over each other.
inception-
Mr.
Pardon me,
Naylor.
Your Honor. Yes, I apologize.
Okay, we're not going to speak over each other.
I
Okay.
apologize.
I wouldn't expect him to produce everything on his phone either. If you want something regarding the LLC and any communications related to that, are there communications she's aware of that she thinks are missing?
Well, they had to be communicating somehow, Your Honor, about how they're going to run, how they are and are going to run this LLC that they cut her out of that she invested into. And we think text messages and emails may show that. And the only way to know they're not hiding them and delivering and giving us everything that might show what they did is to require them to give us the emails and text messages he's been involved with. If you want to limit it to the LLC or anything else involving business operations by respondent during the time period in question, we would certainly be willing to accept that. Anything less lets them hide things under the record.
Okay, move on.
And Judge,
Your Honor.
if you're going to do that, I'd ask for a specific name, the person that we're emailing.
I'll give you a chance to
Yes,
cross-examine.
Yes, ma'am.
Let him get through his questions.
Very good. Thank you. Then more specifically, I apologize, Your Honor, I'm getting a little choked up here. Item number 37, we ask for all records and documents reflecting directives by you, namely respondent, to any financial institution changing account use authorization in the last 6 months. Now, that was from the time when we issued this in July. See, we didn't even go all the way back to the initial the marriage. It was trying to get at what the LLC, how the LLC got cut off, how she got cut out of that. So we asked them about that for the last 6 months. What did you find in the records from that?
There was one document within the LLC documents in the discovery that was the 750 pages that said the other 3 members of the LLC had a meeting and voted to remove me from the business account. I was not notified. That's the only, I was aware of it through my own personal knowledge back in May, but I was never made aware of it by any other member of the LLC.
Did you get a copy of that document that they supposedly voted on and told the bank they voted on?
Not until it was in this discovery that was provided in November.
Okay. So we want that amplified on and set out specifically.
Okay, you're moving away from the microphone again, Mr. Naylor.
I apologize for that, Your Honor. Move the paper out of the way might help. Of course, we want to have a response that says, in response to 37, here's the document and or documents that are responsive to that, no more, no less. And that way we know what's there and what's not there. Moving on to 38, something touched on previously. We asked for all records and documents reflecting income from horse boarding. Of course, this is during would have been relevant to the time of the marriage where he's getting income from it. That would have been community property. What did you find in regard to that?
It was incomplete. The bank statements showed some deposits made from Lisa Hand, who is a boarder, and Chuck and Elaine, who are the other boarders. But it was not complete. Lisa pays $250 a month. Chuck and Elaine pay $750 a month.
Okay. Moving on to 39, Your Honor. We ask for all payments or settlements from or as a result of prior employment by Pantex. What did you find in regard to that request?
The statements that were provided for this account were incomplete. I know the first 4 or 5 months of 2024 are not provided. That was after he had received his first lump sum from the Pantex. And then
Here.
yeah. They're incomplete to where it doesn't show any other payments from Pantex, which I know there have been a couple others.
Moving on to 41, all documents reflecting any apartment ownership or leasing.
None of that information was provided.
Now, Your Honor, if they got it, they were under duty to tell us in their response. We have no documents responsive to this request. But so again, here we are, less than a month out from trial now, and we still don't have tied down information. Moving on, all documents for 42 requested all documents reflecting a horse sale in February or March 2025.
This horse was sold. I know the owner picked this horse up on February 22nd. I was told by Miss Bucker that I would get $3,500 and the remaining $1,500 would be used to pay the lady who comes and feeds while we were gone. He would just use that remaining $1,500 to pay her as she had to work. There was no documentation of any sort regarding that.
And item number 44, all documents related to ownership, control, or sale of a skid steer.
The skid steer is used by the company. It's Mr. Blucker's personal skid steer, and the payments are made out of the personal account, but it has been used for Agent Construction Services businesses, which that payment, I'm assuming, goes into the business account.
So is it safe to say that basically without those type of documents, you cannot track what's going into and coming out of the LLC that you invested into during the time of the marital relationship?
Yes, sir.
Just
Your Honor,
specifically what document we're talking about?
any document related to the ownership, control, or sale of a skid steer, basically if he's getting money in on it, let's see the money coming in. If he's spending money on that thing out from somewhere, let's see where he's spending his money from and going to. Is it coming out of community funds, separate funds, LLC funds? Those are the kinds of things that are covered by that broad request for all documents related to ownership, control, or sale of the skid steer.
Is that it?
Pass the witness, Your Honor.
Okay. Go ahead, Mr. Abbott.
In your petition, you alleged fraud. Tell us what fraud you're alleging.
When Mr. Blucker and I met, he indicated to me that he had been divorced for 3 years. Their divorce was not final for 4 months after we were dating, and I was not aware of that until after he and I were already married when we were filling out insurance papers.
Is that it? If so,
Yes,
I
sir.
need
That's-
deposition. I have the answer to my question now. Judge, if you'll give me a specific list of documents and when you want us to have them to them, I will either provide them with the document or a sworn statement that we don't have documents to that effect. But see, this is what I've been asking for, a list. And it takes a hearing with you to get a list from them.
Your Honor, we have been requesting those documents since July, and we finally got something resembling a semblance of those 6 weeks after we filed a motion that's saying you should not be able to have any discovery because you have intentionally or with gross negligence failed to comply with the 30-day requirement, so this case can't move forward. And here we are within 30 days of trial with them saying now then they'll give us the list and specifically identify it that they should have given us 5 months ago. It's not our obligation to make that list and to get all that information together and to know it and review the documents. It's theirs.
It actually is their obligation, Judge.
No, it's not our obligation to list your documents and say, here's what we've got that's responsive to this request. We've gone through 44 items.
You want to, Judge, and I'm not going to address Mr. Naylor directly. I'm going to address the court as I'm supposed to. If they want documents, it is incumbent on them to give specific documents and not these broad blanket, just give us everything type things.
Your Honor,
This
if
is
they
what I've
had a
been
problem
doing.
with the broad nature of it, they had 30 days to make an objection to it, and they didn't. And now here he is arguing an objection that's been gone for 4 months.
Tell us what you want us to do, Judge,
Okay.
and we will do it.
Do you have any questions that you want to ask of the witness in order to clarify which document she's identified?
Judge, I want you to tell me what documents these are and what you want us to do with them. like the vote on the LLC. I don't know if there's documents to that effect. The WhatsApp, I don't even know where to begin with that. And I don't know if my paralegal wants to confer with me about some of these documents or not.
I can confer with Mr. Blucker because I believe we discussed that some of these he does not have.
Ms.
That's
Wheeler,
why they were
Ms. Wheeler,
provided.
you haven't been asked a question by the court.
I understand, Ashley.
Okay. Okay, let's go down through this list. I really don't think it should be up to the court to make a list. I tried to make notes while the witness was talking about what I thought she was identifying as missing. Let's go through it together and see that we can all get on the same page. I don't think anybody wants to put off this trial setting. I don't think it's in anybody's interest to do so. So we've got to make a plan about how we can get as much information as possible before then. Okay. So the first question that I heard you identify was number 25. And she identified that she was missing any records regarding the Discount Tire or Best Buy credit accounts. I think that one's pretty straightforward. Number 32, there was a specific time period there, and what she's really after is any communications regarding the running of the LLC between the other members. Is that correct?
Yes, and I might amplify on that a little bit, Your Honor. And maybe I skipped over it. I don't, things come and go in these hearings. Item number 3, we requested all letters and correspondence that constitute or contain matters relevant to the subject matter of this lawsuit. And part of what our problem here is this LLC has been operating throughout the whole marriage, and we have no real idea about who their customers are, what kind of contracts they have with them, how long they're ongoing, how much they're getting paid, how much their expenses are, and all those documents should have just been provided from the get-go. So we would certainly, as part of two or three of those coming together, we would ask that all of the information about the LLC tell us this is what we've got. This is what we don't have any responsive documents for, point blank in response to the request that we've asked out there, that we've got out there.
Mr. Naylor, when you say number 3, what do you mean?
Well, all letters and correspondence, including electronic writings that constitute or contain matters relevant to the subject matters of the lawsuit. The LLCs included, and therefore we want to, if we're going to have a list made, we want to piggyback that very global standard request in one that says, give us all your documents that show what's going on with this LLC, how it's doing business, who it's doing business with, payments in, payments out, expenses in, expenses out. And if the answer is we don't have it, or just these 3 or 4 little documents are all we have, tell us that in response to what they actually have by way of documents.
Okay, Mr. Naylor, did you ask your client anything about that? Did she identify anything that she's aware of that's missing?
Well, we know they run a business, and so we know there should be business records, but they need to tell us what they have and they don't have, Your Honor. And if they say, hey, we run a sloppy business here, we don't have any business records of that kind, put it in writing in response to our request for those, the specific request for those kind of documents, and tell us we don't have them.
Okay, so number 3 is going to be any documents that haven't been previously turned over regarding the running of the LLC.
That'd be great, Your Honor.
Okay, the next thing I heard you ask about was number 33, 32 and 33 you kind of talked about together. Those both go into the running of the business. So number 3 would include any electronic communication discussing the business.
Yes. If
Okay.
if I understand the court correctly.
Number 37. Any documents that haven't already previously been turned over regarding how the petitioner was removed from accessing the LLC bank account?
Yes, Your Honor.
Okay. Number 38 was any documentation regarding income received from Borders, specifically Chuckany Lane. And I have Luca Hurd. Is that right?
Lisa
Lisa.
Hand.
Lisa Hand. Oh, my handwriting's terrible. Thank you.
Well, no, for the court reporter, Your Honor, Lisa, I believe is the spelling that will be best.
Okay, thank you. Okay, next one is any documentation regarding income received from his prior employment with Pantech. I believe the petitioner said she knows of other income. Can you further identify what other income you're aware of, ma'am?
Regarding the payments from Pantex, there was an initial one of 90,000, which was reflected in a bank statement. And then I know he received another one later that year. There's not any specific documentation as to whether there have been any additional payments made.
Okay, so later in 2024?
I'm not sure if it was 2024 or 2025. But I do know he's received another one, possibly more, as there was no specific documentation regarding those payments from them.
Okay. Can you tell me what knowledge you have that there have been other payments?
It's in the bank statements is the only, like, as I said, the original one was 90,000 in January of 2024. And I believe there was another one. It may have been October of 2024, later in the year. After that, I'm not sure if there have been any additional payments from them.
Let me try to make it as clear as possible. How do you know there was one in October of 2024?
Specifically from the bank statements reflecting that.
Okay. Other than the bank statement reflecting that, what other documentation are you hoping to get?
To see if there were any other payments other than those two that I know about specifically.
Okay. Are you looking for pay stubs, 1099s? What are you looking for?
Just,
Tax return?
yes,
I'm sorry, what did you say, Mr. Abbott?
Tax return. W-2.
Are those the kind of things you're looking for?
Yes, ma'am. Just any documentation that shows that those payments came specifically from that Pantex.
And I believe you've already identified, or you did identify somewhere else in your testimony that there was a missing tax return, right?
Yes, ma'am.
Okay.
And it was the 2024 tax returns, what I heard earlier.
I believe that's correct. So that needs to be on the list as well. That 2024 tax return, number 10 was the savings accounts. Documentation regarding the AB savings account, the daughter's Amarillo National Bank account. Any documentation regarding, again, Chuckany Lane and their boarding of their horses. Number 18, any documentation in the safe. Specifically looking for registration information for the horse, 3 times a charm. Number 20 was a certificate of title. The truck registration was missing. Number 21, insurance policies from State Farm or others regarding the auto policy, the homeowner's life insurance, his health, possibly through the veterans. 22, loan documentation, specifically missing loan documentation regarding advances in the amounts of 4,000 and 2,000. That's June 10th, 2024 was the 4,000 and September 16th was the 2,000. And then I think we went through 25, 32, 33, 37, 38. And the Pantech, and we're down to number 40, which I believe had to do with apartment leasing. Is that correct?
Yes.
Okay. Can the petitioner tell me, why do you believe there are documents missing regarding the apartment leasing? Tell me that again.
Um, I was made aware that there was an apartment lease in his name, and I just want to know if that lease is still there or not.
Do you know where it was? What apartment complex?
No, ma'am, not specifically. I know it was here in Amarillo. I don't remember the name of the apartment complex.
Do you know what time frame?
It had it from I believe 2018 through April of 2024, I believe.
So we're talking about a prior lease agreement?
When were the parties married? Someone remind me.
They were
January
married
10, 2023, pardon me, June, I meant to say
June.
June 10, 2023, Your Honor.
Okay,
And
so
and they separated in October of 24.
okay, so any documents that have to do with an apartment lease during the period of the marriage, so it would be beginning when they were married through today. That would be responsive. Okay.
Right.
The skid steer, any documentation regarding income received or paid regarding this, paid by the business, received by the husband, I'm guessing, regarding his personal skid steer. Any receipts, bank deposits, anything to do with that. And then there's a horse sale, any horse sale information specifically including a horse that was picked up on February 26, 2025.
Very well, Your Honor.
Okay, so we're gonna see if we can't keep this court date. Let me look at my schedule and see if we can set up some dates. Okay. Well, it's Tuesday. Let's have all those documents in that list. Either you identify that you don't have them or you produce them by 5 o'clock on Friday, the 23rd. So that's this Friday.
Okay.
Okay.
And can you give them a deadline to answer our discovery?
Okay. I do think that you're entitled to your discovery. We are getting close to the court date. So let's see.
I would assume they've already been working on it.
Hmm. I'm going to give you until Friday the 30th at 5 p.m. to get him all his discovery. Okay. Now, is there any reason we can't get the horses, the 4 separate property horses picked up this weekend? Is there any objection to getting that done?
There's 3 separate property
3?
horses.
Okay.
And she has things at his house. He would like her to pick them up.
Okay. Do we need to go off the record and give you a moment to speak with your client about whether she can get that done, Mr. Naylor?
Want to talk, or can you tell them what you think you can do? Happy to do it either way.
Yeah, let's talk about it.
Okay.
Mr. Blucher says she can come out at any point she wants. He just would like it done sooner rather than later.
Okay. So
On February 5th.
okay. Give me just a moment. Gloria, can you confirm that we're live streaming again?
Thanks, Dan.
It is loaded, Judge.
It's still loading. Okay. Give us just a minute so we can get back on the record.
Sure.
It is on now, Judge.
Okay, great. Okay, let's go back on the record in Cottle County Cause 4673. We took a brief recess and we're now back. Mr. Naylor, tell us again when your client wanted to pick up the horses.
Yes, they can get started on that February 5th, 8 a.m. This weekend, just as everybody probably knows, the weather seems to be inclement. Propose not to be trying to get horses and trailers and property this weekend. So we would propose February 5th, 8 a.m. Get the project started on that, Your Honor.
Okay.
We'd be fine with that, Judge.
When you say started, do you anticipate it being finished the same day?
It should be. As you know, with horses, there's always something that might come up. But yes, if I can get it done that day, I will absolutely get it done that day.
Okay. Okay, so was that the only issue we needed to take up in terms of modifying the temporary orders, gentlemen? That was it?
And her items are there also. And so I assume she's going to pick up her horses and her items.
Yes.
Is there any need for clarification about how much stuff she's picking up? You both know what we're
I
talking
don't
about?
believe so, Your Honor.
Okay, very good.
I think the parties will agree what's to go. I think there is when make a list and come back and see
Okay.
the judge.
We can take it up a trial, I'm sure. If something does not go as, we hope it goes smoothly.
Your Honor, just in finishing up my motion, we requested attorney's fees. The other side's requested attorney's fees. Our attorney's fees are responding to this 6-month now delay in getting an order that says these are the things that haven't been provided and set out. I would state the reasonable necessary attorney's fees are in the amount of $2,500.
Judge, we've been asking for a list. Today's the day we get the list. So I'd ask you just to deny everybody's attorney's fees and we'll be off and running.
Okay. Well, I'll tell you, I feel like I'm going to have a more full understanding of this dispute when I hear all the evidence at trial. So I'm going to reserve making any ruling on attorney's fees for both of these motions until we have our trial. And when we get into it, I think it'll clarify if one of the parties is having trouble presenting their case because of it, or if there's something obviously uncovered missing. I think that might come out at trial. So I'm going to go ahead and reserve ruling on all that until we get to trial. Of course, I am going to reserve my right to exclude evidence if it is clear at trial that something has been wrongfully withheld during the discovery process. I think you all understand that.
Yes.
Okay. Anything else that you'd like for me to clarify today?
But otherwise, you're going to deny their 215 motion, I assume.
Well, I'm not going to restrict your ability to put on evidence at trial unless it is shown at trial that there was something specific that was withheld. I won't let that document get in, obviously. But in terms of the request that you not be allowed to put on any evidence on an issue, I am denying that.
So for clarity, we're off and running working on our items.
Mm-hmm.
We want that done by 5 p.m. next Tuesday. That's the 23rd of January. And their responses to us are due by Friday, January 30th at 5 p.m.
No, I think that was a misunderstanding. I want your responses due by, let me make sure I'm looking at the same calendar. The 23rd is this Friday.
Oh, I'm sorry. I don't know why I wrote Tuesday. I apologize.
Okay.
I'm glad I clarified that because I'm not looking at my calendar. This Friday, 5 p.m., that's January 23rd. We'll have ours done. They'll have theirs done by January 30th, 5 p.m. that Friday. She will pick up her horses and her items at 8 a.m. on February 5th. You're denying their 215 motion. You're reserving, obviously, the right to include and exclude documents at trial. I have a list of things we're off and running on. And is that it?
Well, I don't think we clarified whether there's going to be a deposition.
I don't need a deposition now.
Okay.
I asked her the one question I had and she answered it.
Very good. Like to hear issues being taken off the table. That helps the court. Okay. All right, gentlemen. So hopefully you can get this resolved. Has anybody made any motion for mediation in this case? Does anyone think it would be helpful?
I think it'd be helpful if we can do it by February 18th.
Your Honor, I like being very frank on that kind of question. From the get-go on this case, we've said to the other side, if we can get in all the cards, know what we're working with, looks like we ought to be able to get this case settled. And when we get in all these cards, finally, maybe we'll have the information that allows us to get it mediated and settled. So yes, mediation is something that could very well be helpful. If we do that, I guess what I think I'm hearing from the other side as well is maybe we can do that by agreement if it's to be done before the 18th, February the 18th, because certainly it's not our desire to have either side put off the case from the 18th beyond the 18th for mediation purposes. Nobody's going to come in and move for mediation at the last minute.
Judge, I want to
not
get
us.
Donna. I want her to go rope or whatever she does. I want her to win a lot of money. I want to wish her success. I want to be divorced on February 18th. We're off and we'll go get our stuff done, Judge.
Okay, do you have a mediator that you gentlemen like to work with?
Judge, we like to use Mike Sharpie up here. I know you don't know him. There's several mediators. Nobody's as good as Mike Sharpie. Nobody's as good at getting things resolved. If Mr. Naylor wants me to check with Sharpie and see if he's available between here and there, I'll be glad to. I've got someone that's all they do.
With this type of compressed time schedule, I'm in the process of scheduling another mediation in another case in virtually the same time period, Your Honor, and lots of mediators are already booked up. But so I would suggest to opposing counsel here before the court that let's try to work that out counsel to counsel. If we can find who we can find that has an available date that's mutually agreeable. If we were,
I want you to work on trying to get this mediated. I think we're going to spend a long time in court with me trying to understand the finances of these parties, and obviously your clients know it better than I do. So
Yes.
I want you to mediate this case. I want you to both confer. I want you to both of you check with mediators and try to get a date worked out by the end of the week. I understand if you want to try to mediate after discovery on the 30th, but that just gives you 2 weeks at the beginning of February to try to get availability. So try to find somebody that has a half-day availability in the first 2 weeks of February. Call around. You can call around to the one you want, and you can call around to ones you want and try to exchange dates. But I want you to make a good faith effort to get that done.
And not to belabor the point, Your Honor, but did I hear you say you wanted to hear something back from us attorneys by the end of this week?
Well, I want you to communicate with each other by the end of the week about available dates and try to get it set. Start that process of trying to get it set for mediation, because I think that'd be very important.
Richard,
very good, Your Honor.
He either has my cell phone number or he can call the office and get my cell phone number.
Okay, very good. Okay, work on that, and hopefully I'll hear back from you that you've got it all settled and worked out and your clients are both